This application was taken up yesterday when Mr. Parthopratim Rai appeared and says he has instruction to appear on behalf of the respondent number 1 and 2. Although, my lord, he was appearing on behalf of the appellant, my lord. Your lordship, my lord, make it not today, yesterday. But, my lord, today it appears that your lordship will be taking up.
Go back. We'll go back. Don't
So, my lord, kindly take it up today, my lord.
Let us see. We'll go back. Don't worry. Because the others who were waiting for their cues, they.
But, my lord, it's no fault of mine, my lord.
I understand. We'll come back. Don't underestimate.
No. I'm never. I never.
Yes. Let us call. Yes.
My lord, may be permitted to mention one matter, my lord. Your lordship passed an order on 18th, my lord. And my lord, this order was not uploaded, my lord. Your lordship directed us the within.
Don't have the control.
My lord, within 20 seconds, if we do not, my lord, deposit the messenger, already we have.
No, it has already gone. I believe every order has been signed.
My lord, my maintenance order will be vacated. Your lordship directed. If we.
Nothing is going to happen. It will be uploaded.
We have already deposited the messenger cost.
We don't have a control over the upload.
My lord, may I hand over the slip? My lord, if you
He dictated the order in the open court.
Yes.
So you have communicated it. That's all. Comply.
Some portion, my lord, we have not understood.
Not understand. So loudly it is dictated.
No, your lordship. My lord,
then who is
already
to be blamed?
Already, my lord, we have deposited the messenger's cost and others part.
Do it. Yes.
May I have your lordship's kind leave to mention item number 21 of your lordship's list? But there are, I'm not asking for upgradation, but some defects are there. I'll do the matter tomorrow.
Look at it. What are the defects? Curable or non-curable?
But the appellate decree has to be
trial court is a curable, and without that it cannot be. You have to file it.
Lordship, I have mentioning the order has not been uploaded. Order dated 15th of the December.
It has everything is uploaded. Don't worry. Yes. Call the. What happened? Give.
The appeal of the appellant is dismissed and the COT is allowed. COT allowed. Appeal dismissed.
Hiri, do one thing. The name should come here. The name should come here. Hey. নামটা কিন্তু ওখানে একসঙ্গে যাবে না, এটা এখান থেকে তোলা যাবে। We'll sign it. Don't smile. वो डिग्री होगी तो प्लीज डिग्री same thing. Okay, call the next. 3 minutes. Yes,
the appeal is allowed and we have directed for payments to be made within 8 weeks.
hey, আমার নামটা লেফট হ্যান্ড সাইডে যাবে। Item number 4. We do not find that is a fit case for interference with the impugned judgment decree. The appeal is dismissed.
I agree.
Yes. Yes, madam, we do not find any infirmity or illegality in the order. Dismiss, consequence whereof the connected applications are accordingly dismissed. 8. Correction with the A correction star. Yes. Yes.
Lord, I appear on behalf of the respondents.
Appear on behalf of the plaintiff appellant, my lord. The matter has come up on my instance, my lord. My lord, the matter has been amicably settled between the parties. Here are the terms of settlement, my lord.
Both the parties have signed.
Both the parties and the advocates both have signed, my lord.
Two crores they will book after deduction of 80 lakhs towards income tax. Net payable is 1 crore something. And then 5% income tax. The ability of Harish. Yes. What is this English? Apart from the payment, the appellant plaintiff has been appointed afresh as consultant.
He was previous
Appointed as a fresh or a consultant.
as a consultant.
Afresh.
Fresh.
It should be he is appointed as a consultant afresh.
Consultant afresh.
What is this English? Afresh as consultant.
Appoints.
A fresh as consultant.
It should
What
have
is
been
this?
together.
What Middleton Inn or the Lincoln Inn has taught? Or Middle Inn? Which one?
Well,
Lincoln Inn or Middle Inn?
I am no in, my lord.
No inn.
I stay in hotels when I go travel. Like my lord. Lordship doesn't stay in inns.
What is this? Yes. So what is the this appeal arises from what?
This appeal arises from an order in a suit regarding wrongful termination, damage,
What is the impugned order? The appeal, the scope
return of
the-
claim,
My order
dismissal
7
of
rule
suit.
10 petition was allowed by the Barasat court, trial court.
Order 7, Rule 10 was
Rule
allowed.
10.
And plaintiff was directed to
No,
be.
there is no proceeding pending in the trial court. This is really I wanted to know.
Yes.
So we are recording a final so that it will come to an end.
My lord, only thing, the plaintiff was directed to be returned to Pune, appropriate court. And this honorable court had passed
Stayed
an
the
order,
order,
stay
staying.
of that order, so that the records will not be sent back.
Correct.
Will not be sent to Pune court.
Whatever, we will say that disposed of the entire suit. No difficulty. Suit goes.
Suit goes.
So, anything more you want? Stop pending with the-
Jai and Jai.
Objection has been written.
খাওয়াতে হবে ওদিকে ওদের যাও না জানাতে যাও
It is that matter, the rejection application and then order 7 rule 10A was applied.
No,
No.
It is
No.
not. Sorry, then it is a
Matter
different
never came up before your lordship.
Okay, it never came up.
before your lordship.
Before your lordship.
Has it been admitted? No.
Yes. Stay granted.
Okay, stay granted. Without admission or
No,
after
no,
admission?
stay granted in the sense, stay of.
Wait. After admission?
Oh, yes. Well, then the interim order confirmed and appeal direction to be heard. Appeal hearing paper book directions given. Paper books also filed. May I? May I take my lord's leave? Last day. May I take my lord's leave today?
Oh, always justified. Appearance is justified. Noted. Noted. the matter is listed today as the parties have amicably settled their disputes out of court. Today, an affidavit. Today the terms of settlements entered into by and between the parties are filed, duly signed by the parties as well as their respective advocates. After perusal of the terms as agreed upon, we do not find that any of the terms is in violation of the law and therefore treat such terms of settlement as lawful. Since the parties have already settled, there remains nothing in the proceeding to be decided. Oh, stop. In view of the terms and settlements, the instant appeal is disposed of. Let the original terms and should we keep it or a photocopy?
Appeal is disposed of and the suit stands.
First tell me, should we keep the original or should we keep?
Yes, Lordship. We'll apply for such.
Let the original copy of the terms and conditions as filed today be kept on record. In view of the disposal of the appeal, there remains nothing in the suit and therefore the same shall accordingly be disposed of.
Lordship. Grateful, my lord.
The same is accordingly disposed. Shall honor. Let's call the next.
My lord, item number 7, my lord. The appeal, after the appeal was admitted, my lord, the written up notice form along with Tolomanama was deposited on 13 October 2023. And our mistake, my lord, the special messenger cost was deposited on the reopening date on 16/11, my lord. Let it be accepted, my lord. That was out of time.
This is really unlucky. The matter has listed as a logima seeking an extension of seeking an order for acceptance of the special messenger cost and the requisites having filed beyond the period period provided in the order dated 12th October 2023. The office has indicated that the requisites and special messenger cost has already been deposited, but beyond the time so limited. After hearing the counsel, we are satisfied that the applicant was prevented from putting the requisites as well as the special messenger cost. The office is directed to accept the same to have been filed within the time as directed in the aforesaid order. The office is further directed to take all appropriate steps required in this regard. Yes. Deeply.
Please, your lordship. This matter has appeared at my instance. I mentioned the matter since Monday last.
The appeal is valued at ₹100. How can it come?
No, not your lordship there.
I'm asking you, we have not noticed actually on the last occasion.
Your lordship are pleased to.
No, we have not actually. Oh no, we admitted it.
Yes, after admission, your lordship.
Sir, so far as the jurisdiction part is concerned, one has to look into it. The stamp reporter probably did not indicate that it is. It simply says in time and in form. There is no noting. So we proceeded on the basis thereof. Now the court officer has indicated that it is valued at ₹100. And this is an order, and this is an order passed by
Additional district judge, first track court, 1, Alipur.
Wait. It is not an original jurisdiction. Now, the question is whether this is an appellable order.
Yes, it's an appellable. On the last occasion, admission allowing order 22 rule 10. It's appellable.
Order 22 rule 10. It is order 23 rule 1.
No, my lord. Order 22.
There are two parts of the order.
Yes, the first part. I am considering the first part.
Okay. Let us see.
Yes, Lord. Because at the time of admission, your lordship questioned that whether it was appealable or not, and it was checked up. Order 43 rule 1L. Both.
So where do I get it?
The order 43 rule. The first part of.
Order 22 rule 10. Yes. Then
it is appealable.
ওটা appellable এখানেই হবে. No problem. Yes.
Yes, I'm grateful to your lordship. That was the.
Then why it has come up? For that purpose?
Actually, your lordships are pleased to admit the appeal. After admission, Lord,
No, we directed to serve the copy.
Yes, already I have served, including the learned advocate.
So let it appear in the application.
But Lord, I paid for ex parte stay because the.
What ex parte stay?
No, actually.
What stay?
The appeal is going on. Appeal is going on. And the respondent number 7.
This is against which judgment and decree? Against a judgment and decree. What is the nature of the judgment and decree of the trial court? I just wanted.
Appealable. That's right.
No. I am asking what is the nature of the judgment and decree passed by the trial court?
Trial court is suit for declaration and permanent injunction that has been dismissed. Yes.
And then the appeal is continuing.
The thing is that the appellant.
Nothing. There is nothing.
No, actually, the learned.
Which application you have filed?
May I submit, Lord? Order 22 rule 10. Actually, by that
you did not have to say. We understood. Where is your affidavit of service given?
Yes.
Door locked.
So then it's a peculiar.
Insufficient address. Insufficient address.
But they are, for abundant caution, your lordships are pleased to direct the petitioner to serve the learned.
Have you served? Where is that?
Yeah, that has been.
Where is that?
Yes, at page. Yes, annex chair, next lordship can you see? The last one, 9. The learned advocate who is appearing on behalf of the opposite party.
Let the affidavit of service filed today be kept on record. Despite service, there is no representation on behalf of the respondents. It is submitted by the learned advocate for the appellant that the court of appeal below is proceeding with the hearing of the said appeal, and unless the Same need, it would render the instant appeal infructuous.
Yes.
The instant appeal arises from an order by which an application under Order 22, Rule 10 of the Code of Civil Procedure is disposed of.
Allowed. Allowed. No, I'm sorry.
You dictate.
I'm sorry. No, I'm sorry.
Hey, chale jao ghar.
No, I'm sorry.
You dictate.
It's a slip of tongue. I may be excused. I'm sorry.
Disposal means both. Disposal means both.
Yes,
Either allowed or rejected. What? So we have used a very common
Yes, sir. No, that's right. Well, it's my fault. It's a slip of
disposal. You will listen. Under Order 22. The body is disposed. The appeal has been admitted on 30th of November 2023. In the event the hearing of the appeal continues and disposed of before the instant appeal is decided, it would cause prejudice to the appellant. So, in such view of the matter, there shall be stay of all further proceedings in title appeal number 62 of 2019, pending before the first fast track court at Alipur for a period of 8 weeks from date or until further order, whichever is appear. So, the learned advocate for the appellant is directed to communicate this order to the learned advocate appearing for the respondents before the court of first appeal below immediately, and shall file the affidavit service on the return appeal.
I'm grateful to you.
Let this application, the application as well as the appeal be listed 2 weeks after the reopening of this court following the Christmas vacation.
I'm grateful to you. Much obliged to you. Thank you.
Copy the order. Lord, I'm humbly praying for extension of the order dated Lord 10th October 2023. This is Lord an order of extension. Original order is dated 27th of September 2023. Your Lordship's pleasure was, Lord, that I should serve again an affidavit of service. Lord, if your Lordships are pleased to, Lord, see page 8 of the affidavit of service. This is the first refusal. Page 10, my lord, is the second refusal. Page 12, my lord, is the third refusal. And page 14, my lord, is acceptance by the first respondent. So, my lord, apart from respondent number 1, other respondents have refused to accept, my lord, service.
Anybody communicated to you that he has instruction to appear for?
No, my lord, we have not been informed.
Yes?
No, we have not received any such
Any
intimation.
such communication?
No, my lord.
The matter has come up for extension of interim order. The interim order was extended lastly on 10th of October 2023 for a period of 10 weeks from date or until further order, whichever is earlier. The appellant was also directed to communicate the said order to the respondents and file the affidavit of service on the written appeal. The affidavit of service filed today reveals that the respondent number 1 received the copy of the said, received the said order, but the other respondents refused to accept the postal article tendered to them. In such view of the matter, we treat the compliance of an order dated 10th October 2023. So, the interim order granted earlier is extended for a further period of 8 weeks from date or until further order, whichever is earlier. Let the application be listed 2 weeks after the reopening of this court following the Christmas.
I'm grateful to you.
Okay.
May it please your lordships.
I pay for the respondent. কেন কল করছো? কেন কল করছো?
This is activity.
It's a hearing matter. চলো দেখি. Where is opposition?
My lord, this is my affidavit in reply. My lord, opposition has been.
Where is time to file opposition was extended till
Yes, my
18th.
lord.
My lord. ঠিক আছে. Opposition now. It's a virtually and hearing matter. One day, today is the only day. We are keeping it on a reopening.
Please, madam.
So when we can keep it on second or
Yes,
third?
madam, second, I have
My
noticed.
lord, third would be third lordship. Second is a little difficult. Second is a little difficult. Third, my lord.
Third,
I'm at your lordship's disposal.
Yes.
Whenever your lordship.
let the affidavit in opposition and the reply filed today be taken on record. List the matter on 3rd January 2024 under the same heading. Fixed matter.
Yeah. My lord, let it retain its position in the list, lordship.
Fixed matter under the
Grateful.
same heading.
Grateful, my lord.
Yes, call.
My lord, I appear on behalf of the appellant petitioner, my lord. On the 3 applications we have filed, my lord, this is the affidavit of service, my lord. Pursuant to your lordship's.
Sound drowsy is drowsiness. Which is what is this? Have you served?
Yes, my lord, this is my affidavit of service. You have accepted.
But I am for the respondent.
Now, my lord,
What is this?
My lord, I am for the appellant, my lord. I have filed an disappeal challenging the order of restitution under section 22 of the Special Marriage Act.
It's a matrimonial case.
Yes.
Okay. This is again a matrimonial.
Matrimonial one.
Matrimonial.
And for
What
the
you want?
I'm for the petitioner praying for after vacation, service not completed.
Service is not complete. Order kora dorkar nahi. Not this week.
For the appellant petitioner. Pursuant to minors direction, I have the defendant appellant petitioner stood for partition. The issue is my father got patta in the year 1970. That property was
What? The preliminary decree or final decree? Tell us.
preliminary decree.
So you have filed a challenge and appeal.
Yes.
So usual order, which is passed.
Now, only one thing kindly comes to the.
We can't stay the order. That's the usual order.
Why I am praying?
Commission work will continue.
Why I am praying for stay? That is the point.
Yes.
In the year 1970, my father got patta from the state authority.
Correct.
Now, father subsequently transferred the case land in my favor.
Correct.
At that point, there is no the prohibition imposed in the act. In the act, the prohibition came in the year 75. Now, these challenging that deed, plaintiff number 1 previously filed a suit. That suit was dismissed. And another suit filed by the plaintiff number 1, that is also dismissed. Now, by the impugned judgment, the learned court below directed, taken into consent, this is the Ajmal property, and says that there is no legal title passed by virtue of this deed. Only the point involved at that point, from 75, the restriction come. So, the deed which I got patta, my father got patta in the year 70. So that was, there is no the restriction. So that property cannot comes in the Ajmal property. So if the commission work the proceeded with that, that will
there are two consequences in the appeal. Either the court may not accept your version and accepted the version of the trial court may reject the appeal. Then the scenario would be that it remained an Ajmali property. Or if the court interferes, then the court may hail that it is not an Ajmali property. That stage has not come as yet. So in order to strike a balance, simply because you have a right to appeal, the entire proceeding has to be stayed or the operation of the judgment has to be stayed is causing a greater prejudice to them. In the meantime, if the partition commission work continues, at least some progress has been made. It is only for the purpose of final decree. One has to stay hand because in either the share may be altered or there may not be any share. So ultimately the partition commissioner will do that. You are a veteran. We permitted you to make submissions, but don't make a submission which is absolutely lopsided or one-sided. We appreciate it, but we can't decide and say that you are correct without hearing him.
No, that.
So when we say the usual order, why usual orders are passed? Just to strike a balance. It's absolutely a premium given to a losing party that he has a right of appeal, so the appellate court will stay the everything because he has a right of appeal. Is it a correct way? Yes, we are saying partition commission work will continue, but no final degree shall be passed.
One thing only, my lord, because my lord,
your client is here.
My lord,
your client is here.
No. My lord, only, my lord, I am drawing your lordship's kind attention to section 49(1)(a), which is a patta property. Patta.
That we have to decide.
Yes.
If the affidavit is satisfied today, we can do that. Has been filed assailing the preliminary decree passed in a partition service. According to the appellate, The pata was issued before an amendment having brought into the statute. And therefore there was no embargo at the relevant point of time in dealing with the same. We are not going to decide the same as it strikes at the root of the matter. It appears the prayer is made for a stay of the operation of the preliminary decree, which in our opinion cannot be granted merely because a party who suffered a decree has a right of appeal. Even a provisions contained in Order 41.5 of the Code of Civil Procedure does not envisage automatic stay of the execution proceeding or the operation of the order, or they are filing of an appeal before the appellate court. We therefore feel that a strike a equilibrium between the rights of the parties. The justice should be served if the partition commission work is allowed to continue until the stage of the final decree. In such view of the matter, the instant application is disposed of in the following manner. Next, the trial court shall appoint the partition commissioner if not already appointed to take endeavor on the basis of the preliminary decree to take endeavor of filing of indicating the division of the properties on the basis of a preliminary decree. The parties shall be at liberty. In the event the partition commissioner files the report, the parties are at liberty to raise objection if they so feel, and the court will take the evidence in this regard. However, even after examination of the partition commissioner, the court shall not pass a final decree nor adjudicate upon the said objection until the disposal of the instant appeal.
And my status quo may kindly be maintained by both the parties through further construction.
I have no courage to pass an order on oral prayer.
Well, it was their status quo.
I have no courage.
Kindly expedite the hearing of the appeal. I shall.
You are appearing for the only respondent?
All respondent.
Only one respondent?
No.
You are all. Let the lower court record be called for through special messenger at the cost of the appellant. Such cost shall be deposited within 1 week after the reading of this court. It is however made clear that the trial court shall keep the skeleton record for the purpose of commission work while sending the record to this court, so that it may not hamper such exercise by the partition committee. 2. After the arrival of the lower court record, the officer examined data and found complete sets of a notice upon him. Paper book 4 weeks from the date of service of notice of arrival by the applicant. Since the respondents have entered appearance, have you filed Mogalatama?
Can't say whether my junior or my filed it or not.
Without junior, you are appearing.
But he has instruction the matter will be taken up after recess, my lord.
Oh, no. Since the
For us, he
respondent
skipped
has
the
appeared,
instruction.
the service of notice of appeal is waived by the let the Mokaladama filed by the respondents. The learned advocate appearing for the respondent could not divulge could not disclose whether the Mokaladama executed by the respondents had been filed in the department or not. In the event the same is not filed, he gives an undertaking to file the same within 1 week after the reopening of this court. After the filing of the paper book, liberty is granted to the parties to pray for early hearing of these.
Yet, order of status to be my usual order.
No, correct, sir. My brother has also, he will all join me. No, after AIR 1994 Supreme Court and after 2006 Volume 3 SSA, that is the Kishore Kumar State Act case. I have no courage. My brother have also gone no courage.
was to serve upon us the applications as well as the memo. No memo has.
Memo is not.
And my lord, the second thing, my lord, if my lord has, my lord may just kindly take can 1. If my lord may kindly just, my lord,
What?
my lord, there are 2 orders, my lord, from which appeal has been preferred. His cause of action arises from the order dated 1st of December 2021.
What we will consider, we have not applied at mind. He
Very
has
well, my
asked for an adjournment.
Very well.
Great.
My lord, any date has been fixed?
Next, after vacation, obviously, we will retain its.
No, after vacation.
Next.
The learned advocate Usha Maiti is appearing, my lord, in this matter.
For the respondent?
Yes, my lord.
Who is for the appellant? You are for the appellant?
My lord, this is the application for substitution.
Then come on the appellant side.
Lord, would your lordship kindly allow me to make my submission before your lordship, my lord?
Second appeal is before us.
Defend number 1 is the appellant before your lordship.
Why the second before us not has been admitted?
No, my lord, your lordship was pleased to direct this matter to appear under the heading application yesterday. My lord, this is an application for leave of the honorable court to implement the heirs and legal representative of plaintiff number 3, plaintiff respondent number 3, who died on 23rd March 2023 after the judgment and decree was passed.
Can 1.
Can 1.
Can 1.
This is the application.
After the judgment and decree was passed by the learned appellate court below, my lord, and before filing of this second appeal, plaintiff respondent number 3 had died.
And respondent number 3 has to be deleted. The name of the respondent number 3 has to be deleted.
Yes, my lord. Maimulin Malik.
Yes. Oh.
Maimulin Malik.
But you have sought for a leave. You
Yes,
have
leave.
already completed.
No, this is an application.
Paragraph number 7, your lordship kindly have a look to paragraph number 7, page 10.
The application has to be a leave to proceed against the heirs. Where is the application? Nothing. Can 1 is an implement. They are already implemented.
But your lordship kindly have a look to page 10, paragraph 7, your lordship.
Come to the court of self-procedure.
146 and 146, possibly 146, your lordship.
What it says?
But that is, my lord. Section 146 of the Civil Procedure Code, your lordship will find the proceeding by or against representatives.
So, will you not seek a leave, implement? If they are already implemented, it's only a leave stating that he died after the judgment is delivered and before the appeal is filed.
My lord.
So only the leave.
Only leave is required.
Though the prayer can one, though the prayer is couched in a different manner, but we find that a leave is sought to proceed against the heirs and legal representatives of the deceased respondent number 3 who died after the judgment was delivered, but before the appeal was filed before this court. There is no impediment in proceeding against the heirs and legal representatives of the deceased respondent in view of the provisions contained under section 146 of the procedure. Accordingly, the application is disposed of, granting leave to the appellant to proceed against the heirs and legal representatives of the deceased respondent number 3. Two after vacation. So put up the matter for admission under order 41. Has not been admitted. Comes.
I'm grateful.
I paid for after vacation. Hold on for the application.
Appeal arises from
Dismissal of
applications.
one application for condonation of delay.
Have you served?
Yes, another application for
Condonation.
granting leave to file appeal against the deceased respondent, defendant number 2, who died after the dismissal of the suit and before filing the appeal. Partition suit dismissed on the ground order 2 rule 2 and res judicata. Since a previous suit
Partition suit res judicata.
that has been considered and rejected on that ground only. Since earlier an injunction suit for injunction has been filed, that's why this suit is not. Section 5 is can 1. There's a delay of 200 days. There is a settlement was going on.
How much delay? 200 days.
200 days.
No, 700 days.
700.
You have said.
No, 200.
You're fair.
No, if it is considered after taking to the certified copy and all.
Our staff reporter has said only 55 days.
But I made this application for 200 days. It's subject to correction is my fault. In prayer portion, I have written wrong. In paragraph 13, I have rightly mentioned. In paragraph 13, 200 days, if it is considered taking note of the lawsuit without taking note of the certified copy, and if it is considered taking note of the certified copy, it will be 70 days, as per mine.
What are you talking about, sir?
200 days.
You have filed the appeal on 3rd of October
2023.
23.
Yes, madam.
3rd October 2023, August. How much days delay?
Impugned order is of March 2023.
Correct. So, what is the period of limitation for second appeal? 90 days?
90 days.
So, you have filed an application for certified copy on 1st of April.
Yes, madam.
April means 1 day only.
Yes.
And then from 10/5/2023, again the limitation will start because this period will be excluded.
Yes, madam. But if it is excluded, it will be in my calculation, it will be 70 days.
Sorry.
But kindly see the
700.
Kindly see the paragraph 13.
You see the prayer.
But I have made a mistake. But can you see the paragraph 30? I made a
This is an application for condonation of delay in filing the instant appeal.
It should be 70 instead of it's 700 days. I'm sorry.
Though it is stated in the certification that there is a yes, but the staff reporter indicated that there is a be that as it may, the data is not clear. What is material is the sufficiency of the cost shown by the after the despite the not filing these specific according to the filing the appeals control, the application is allowed. There is a brief application.
No, my lord, that is scan 3.
You are a non-party.
My lord, the heirs of the defendant number 2 is required to be added as defendant number 2 died after passing of the decree and before the filing of the
Why?
No, my lord, kindly come.
This is a leave to proceed against the heirs.
Yes.
When he died?
But he died
6/9.
6/9.
6/9, and the judgment was delivered in March.
March.
And appeal was in
October.
In between.
In between.
Entry. This is an application at the behest of the appellant seeking leave to proceed against the. Have you treated them as a party?
Yes, yes, my lord, I treated them as a party.
Against the heirs and of the deceased respondent number 2, who died on 6/9/2023. Who died intestate on 6/9/2023. The heirs paragraph 4 of the applications are already implemented as a party in the instant appeal.
No, madam, in the memo of appeal, I have not implemented. In the memo of appeal, not implemented. But in the application, I have implemented. In the memo of appeal, I have not implemented. In the application, I have said.
How can you?
No, madam, in the second.
It is stated that due to inadvertence, the said respondent number 2, C's have been included as a party in the instant appeal. It is stated that the construction was prepared on the basis of a decree drawn up by the trial court, which contained the name of the respondent number 1. And therefore, such mistake is unintentional and committed due to the mistake. Considering the explanations offered, the disposal of the instant appeal, the mention of the name of the respondent of the perspective of the referendum of the and implement of the heirs and development as disclosed in paragraph 4 thereof as respondent 2 series 2A, 2B, 2C, like that.
Yes.
Office is directed to make necessary correction in the matter. It can 2 be listed 1 week after the vacation. $268.
268 lawsuit, I am appearing with the defendant appellant lawsuit. Suit for partition against appeal against the application 1 section 5 and another is section 5 61 days delay.
Sir?
Yes, yes.
I'm not on the way up. Kindly give the main application after the vacation.
Can 1 is a section 5.
By way of this application, the appellant has paid for condonation of the delay 61 days in preferring the appeal. You are for?
No, I'm for the respondent. It's number 6.
Plaintiff is 52 days. 61 days in preferring the appeal, which as per the stamp reporter has been quantified as 52 days. Stop. You are for defendant
Respondent number 6.
Then counsel for respondent number 6 is present. Is there service on the others?
Yes, caveat, filed the caveat, so
I was on caveat. 6 has filed a caveat.
all have filed caveat.
No, only 6 has filed a caveat.
No, then how can it be?
How
It has
can
to
it
be
be?
served
Sir,
upon the others.
Without direction loss, I
No,
cannot.
sorry, it has a direction.
Respondent number 6 has appeared. The remaining respondents are not in appearance. Who has filed caveat?
Well, respondent number 6.
Only for service, the matter is adjourned.
Both the application service, both the application loss.
1 week after.
We're praying for after vacation.
Let it be taken up after vacation, right? One week after.
Appellant.
7 p.m. 1 week after.
I appear for the plaintiff appellant, my lord. Mr. Shaktinath Mukherjee is leading us. There was talks of settlement going on, my lord, between Mr.
Yes, my lord, I am for the respondent. My lord, Lordship would recall, my lord, Lordship had directed us to go to Mr. Mitra such that the issues can be amicably resolved. My lord, there was a meeting with Mr. Mitra last Sunday. And what fell from Mr. Mitra was if both the brothers can sit together, my lord, all the controversies will come to an end.
Not this week, it in between.
Can it be fixed on 4th, my lord, subject to your lordship?
Not this, 4th.
My lord, any day in this,
4th.
any day after 4th, my lord, because my lord, my client is in judicial custody, Lordship knows. My lord, now, my lord,
Let it appear on 4th, my lord, then there are, because
Very
we have
well.
come to know that even after the concession that was recorded before your lordship, that nobody will deal with the property. They have handed over certain properties to a developer again.
no, I am not aware of all these
We will
things.
bring
my
it on
lord.
record.
4th, I'm grateful.
Good.
72, your lordship, I beg to appear on behalf of the respondent.
Eighth page, 9th.
Lordship, I directed exchange of affidavits with respect to the stay application. My lord, we have received my learned senior friend's affidavit just day before yesterday. Lord, we need
May I
some
file
time,
my
my lord,
affidavit
to
in opposition, Your Lord.
use the
I'm being
reply.
led by Mr. Owen Banerjee.
Extension of time.
Extend, and we have to, my lord, because they have filed it beyond time, man.
If the applicant opposition,
My Lord, plaintiff respondent, Your Lordship.
plaintiff respondent be taken on record. The counsel for the appellant submits that the copy whereof was served day before yesterday. Therefore, prays for an extension of time to file reply. Let the reply be filed within 1 week after the reopening of this court on the petition. This is the matter.
Grateful, my lord.
Let's call the next.
My lord, this application is for cancellation of the Wakarutlama, present Wakarutlama and engagement of a new advocate on record.
Yes, yes, yes. Yes, yes. Let the file come to us. What is this application? Application number?
My lord, 5, my lord. Can 5 of 23.
No, no. ওর কাছে আছে জজের প্লিজ এটাকে তো দিলাম ঠিক আছে
An application at the behest of the appellant. You are the appellant?
Yes, sir. Yes, my lord.
The cancellation of the Kalanama executed. Who was the advocate? Executed in favor of Mr. Sojan.
Onok Bhattacharya.
Bhattacharya. It is after perusal of the amendments made therein, and the fact that the appellant does not intend to proceed with the said learned advocate in whose favor the Wakalatama was executed. Come on. We grant, we dispose of the application, cancelling the Wakalatama executed by the appellant in favor of Mr. Sojan. Yes. A further prayer is made to appoint another advocate. Is open to the appellant to engage any other advocate of his choice. Let the other application be discussed after vacation.
Section 5 has already been allowed. Now I am pressing this.
Without imposition of cost.
No, this. Yes, yes. From 274 to 274 to 281.
It matters.
And acquisition matter?
Yes.
No, subject to approval of the lordship. We want to ready to deposit cost for the record and also to prepare
Deposit in
paper
that, you deposit the money as per the impute judgment and decree with the registrar general of this court.
Yeah, some time may be given.
Okay.
4 weeks time maybe.
No difficulty. You have to 4 weeks time. No difficulty.
Yes, 4 weeks time.
This is an application. Taking its T execution certificate.
Execution case number.
Well, I have brought the list, all the executions.
All for the mistakes of the execution case.
Hey.
The instant appeal arises from an order of the elector disposing of the rentals under section 18 of the Land Acquisition Act. 1890 Land Acquisition Act, Act 1 of 1890.
1894.
What is the
Covers to
the Land Acquisition Court has not considered the enhance the market value and awarded the composition which is not in tune with the facts and circumstances. All the money which is taken by the others. Since the right of appeal emanates from a statutory provision, and in the event the execution is proceeded with, it may have some impact. We feel that the further proceedings of the execution remain stayed until the disposal of the estate. However, while exercising such discretion, we cannot overlook the right of the respondent who emerged successful in the lower tier of the judicial system. And therefore, in order to strike a balance between the rights of the parties, respective rights of the parties, we feel that the conditions may be fulfilled for granting this plea as straightforward. We therefore direct the appellant to deposit the amount in terms of the improved order of the LA court with the Registrar General of this court within 4 weeks from date. On deposit of the aforesaid amount, the Registrar General shall invest the same in an interest-bearing fixed deposit in any nationalized bank and shall continue to renew the same until further.
50% may be allowed to.
That if you come, then you will consider.
The
You have to make an
Supreme Court has also.
My judgment is just now the Chief Justice is something different.
Well, all through.
I have to go by no, all through. That is why I tell you.
Supreme Court also. Supreme Court.
It was the argument where it was advanced. It is all through a usual order which is passed. I have been very critical on that and say that
No, Supreme Court. I have got a Supreme Court judgment. This
Supreme Court, we have considered it and says our Article 142, not a law. We have been given all those judgments. Read that division bench judgment of the Chief Justice and me.
But Apex Court has.
Apex Court I have that was
Considered.
cited. We say that these are all in exercise of powers under Article 142. It is not a judgment under Article 141. We have held.
So, Mala, we will prepare the.
You have to file the application. We are not saying
No, not that.
it cannot be done.
No, we shall deposit the paper, cost for the bringing
Let us see
record.
first.
Yes.
Let us impose the conditions first. In default of the deposit of the amount within the time indicated herein above, it is open to the respondent to proceed with the execution case
irrespective of the fact that the appeal is pending before this court. There shall be an unconditional stay of all further proceedings in the connected execution case for a period of 4 weeks from date. We have granted 4 weeks time, so we have to stay for 4 weeks. The application is thus disposed of if I have not said anything.
Liberty may be given to filed application.
You're right under the statute.
Kindly indicate that, my lord.
No, it's not required. Next, appeal. Appeal will appeal. Let the lower court record be called for through special messenger at the cost
Of the respondent. The cost to be
Such cost
deposited
shall be put in
within 1 week after.
the reopening of this court following the Christmas meeting.
ঠিক আছে তো?
After the arrival of the lower court record, it has to examine. Notice under Rule 12 of Chapter 9 of the Application Rules about the advocate and record of the respondent. The respondent shall prepare 8 copies in for the paper book within 4 weeks from the date of service of notice of arrival. In the event. Now, since the respondent has entered appearance, the appeal shall be treated ready as regards service. After the filing of the paper book, liberty is granted to the parties for early hearing of the instrument.
There are separate execution case number.
What is the separate
execution case?
I have given the item number and everything.
Please tell us in which case, what is the execution case?
I have given item number and execution case number.
All these orders will remain in all the matters.
প্রত্যেকটা item number দিয়ে কি?
Up to 281.
Yes, up to
81.
You are appearing in all such matters. Good.
Deeply obliged.
And my lord, power should be filed, my lord, 1 week after.
They will not find power.
No, the learned advocate, my lord, he has gone out today without.
Oh. Let me since the respondent has
Let the advocate.
appeal shall be treated as regards service. However, the counsel for the respondent undertakes to file wakalatnama
within 1 week after.
on behalf of the respondents within 1 week after the reopening of the court.
Yes, sir. Please. I'm grateful.
Diplo.
Of the next 22.
Lord, I'm happy for the appellate, Lord. It's my application for stay of the operation of the order, Lord. Have we searched it through? May I file this affidavit of service? আরেকটা কপি দেবো, দুটো কপি দিতে হবে। Affidavit of service. Lord, I'm seeking for praying before Lordship for a stay of the operation of the order out of a partial suit filed by the elder brother. May I tell you, Lordship, the facts is very short.
What is the nature of the
Suit, but the impugned order is that the decree partial suit has been decreed in plenary form.
So,
Without considering,
the copy?
Lord, actually, Lord, I have filed the affidavit of service. Affidavit of service I filed it.
There was a direction for two. There is no direction.
No, there is no direction. Direction, no, this is appeal for first time.
You can't serve of your own. That cannot be
Lordship,
done.
I'll give up. Will serve again, Lord.
Service, take it back.
Lord,
After vacation.
But may I little open my mouth for a stay because the proceeding is continuing there for the final decree for appointment of commissioner.
Order when an appeal against the preliminary. The partition commission work will continue. We will not arrest it. Only the final degree shall not be passed. That is
Lordship.
what we will do it.
My Lord, kindly.
Now the court is also closed. Come after them. Service.
1 week after it.
And do something. In addition to the same, the service may also be affected upon the learned advocate representing the respondents in the trial court.
Barashat.
Both ways. So
Both
that
ways. Actually, Lord. Good.
Lord, in this matter, my lord, I am appealing for.
Hello, I am for
supplement. But today, my lord, I have received the copy of the affidavit opposition.
What is this application?
No, no,
Opposition?
Yes, my lord. Today I have received and I will file the affidavit reply.
The learned advocate
And
for
my
the
lord,
applicant
also, my lord,
submits that he has received the copy of evidence opposition today
today.
and therefore pays for extension of time to file reply. Let the reply be filed within 1 week after Christmas vacation. This is the matter according.
Also, my lord, there is one, the judgment was passed on 26th of June 2019, but the decree was never drawn up. Decree was drawn up, my lord, in the year 2020. My lord. That facts need to be brought before your lordship, my lord, so that, my lord, one supplementary affidavit may be deeply granted.
Application is hearing fixed in for hearing.
So opposition has been filed to what? Section 5?
Section 5.
So he has a right to reply. You may get an opportunity to file opposition. Will he not deal with your allegations in the opposition?
No, unless your lordship directly.
So section 5, it has to be heard.
My lord, also,
Then the affidavit opposition be taken on.
No, application we take with you for I think. Filing the.
my lord, also, my lord, we are
Violates, we have indicated.
to allow us to file supplementary affidavit.
Read order 20, rule 5 or rule 6. And order 41, rule 1, then seek for a leave.
Lord, this is the application of the respondent. Permission for withdrawal. Money has been deposited. Now, my lord, they have deposited lesser amount. In the execution, we claim more than 5 crores 50 lakhs. Or after that, they have only deposited 2 crores 77 lakhs. But still, then, my lord, your lordship allow us at least 50% of the deposited amount. And here is the order passed by your lordship. Similar order passed by your lordship. Other order is also there.
Undertaking.
Suddenly, your lordship, I have given the order passed by your lordship in other. And similar order in other cases also there. হ্যাঁ আন্ডারটেকিং সবে থেকে আন্ডারটেকিং একটা দিতে পারি কোনো বন্ড না একটা এভিডেভিট ইন দি ফর্ম অফ আন্ডারটেকিং কোনো প্রবলেম হ্যাঁ তো আমরা একটা এভিডেভিট আমরা করে দিতে পারি undertaking is there in your lordship's order.
Same order.
এই আমাদের নামগুলো দিয়ে দাও সৌরভ
হ্যাঁ
মাছ আবার দিল
বিপ্লবী
It's called the
285. Yes, ma'am. My lord, I am for the appellant, my lord. My lord, suit for specific purpose of contract, my lord. My lord, suit was dismissed, my lord.
So
My
what
lord,
is the
the learned trial court hold that, my lord.
What is the application?
My lord, the injunction application not to transfer the suit property, my lord, to any third party during
Was
the.
there any injunction enjoyed by you during the pendency of the suit?
No, my lord.
So, can you serve and come back?
Right.
Now, 1 week after the issue.
Get.
Yes, next.
But I'm for the response.
My application, I am the appellant. Well, the application for amendment of cost title of the memorandum of appeal. Cost title of the memorandum of appeal, since my lord, the appeal was filed on the date person. And this notice subsequently brought at the time of hearing.
What?
By the opposite party. By
What?
my,
What?
May I take? My lord, this is my lord, my application, my lord, for leave to present the my lord, memorandum of appeal, my lord, on the heirs of the deceased, because who has expired, my lord, during the pendency of the suit. My lord, it was first time, my lord, disclosed by my learned friend Mr. Mukherjee during the my lord, pendency of this appeal, my lord. That is the whole difficulty.
It's order of remand.
Yes.
But has already admitted the appeal. But after
Pointed out, he died during the pendency of the appeal or
suit.
No.
Appeal during the pendency of the first appeal.
What? You have to speak for what?
Leave to my lord,
Leave. Or there is something which has to be done.
Leave is in between, after the decree and preferring of the
addition of party. Addition of party.
146 is after judgment.
Before filing.
Again, no difficult. But leave here.
Addition of party.
So, pick out.
That addition of party, my lord, I have given the particulars, my lord. She will kindly add. Page 11, para 17, my lord, I have given the particulars. Page 11, my lord, para 17.
No. The 17 is order 41 to 27. Which application? Can 1 or
can 2? No, can 3.
Oh. You're looking at can 1. Paragraph?
Page 11, my lord, para 17. এখানে কি অ্যাপ্লিকেশন ফাইল করা উচিত? একটা তো স্টে Oh, একটা অ্যাপ্লিকেশন এক্সটেনশন, right?
So she is still regarded as respondent number 4.
4 Shobita Das.
Where is then who will represent the minor? There is a minor son. You have not said that who will represent the minor.
I mean, Amol Chandra Das, father, natural guardian, and father.
Said so.
Yes, my lord, paragraph 18. Paragraph 18.
Yes. So the judgment also needs to be corrected because his name was not incorporated in the appeal.
Not because that was not brought before the first appellate court.
Yes.
You have to just make it not corrected. Now the appellate court is this court's decree will take care of that.
Because it's an order of remand, that's why
under the civil rules and order, if the substitution or addition has been done at the higher level,
percolates down.
Percolates down.
And civil rules and order. It may have some difficulty with regard to the fact.
Difficulty.
No, since that was not done before the first appellate court.
No difficulty.
Since decree passed in favor.
It is a poison in your mind.
No. No. Decree passed in favor of a dead person. Here.
Should we remind you of the proposition of law in this regard? Whether the decree is a nullity having passed in favor of a dead person or against the dead person?
Yes, against.
Against.
That's why, my lord, I am.
So why you put a poison and inject a poison in the mind?
No.
I think is required when the appellate court, when we will dispose of finally, we know what we have to do. There are two ways. One is either we accept the order of remand or set aside the order. And if we set aside the order of remand, then this degree will go. Yes. So why you are apprehensive?
No, my lord.
Only injecting a poison. This is an application camp sheet.
May I take your lordship's leave, my lord? Extension to place code.
The addition of the parties disclosed in paragraph 17 of the instant application on the demise of the respondent number 4 who died intestate on 14/1/20. It appears that this respondent having died during the pendency of the appeal below, but none of the parties took a step to bring the heirs and the representatives on it. There is no impediment on the part of the higher forum to bring the heirs and the representatives on record by way of an addition. In exercise of power under Order 1, June 10, within bracket 2 of the Codice Procedure. Technicalities should not overweigh the substantial justice. Where is the Judge Ram's case of the Supreme? This is the partition.
No, the partition. No. Declaration, my lord. Declaration of power. Both sides, my lord, are claiming counterclaim as well as, my lord.
The instant appeal arises from proceedings initiated for declaration of their right, title, and interests in respect of a property, and therefore they be on a technical grounds. Should have
another way.
larger impact on the rights of the parties and also generally we therefore put up the instant application directing the revision of the name of respondent number 4 from the category of the respondents and direct the addition of the persons named in paragraph 17 of the instant application as respondent number. What is the last number?
Last number.
7 is there as respond.
7.
7 is a
7 is there after 7.
Respondent number 8.
Oh, Baba. No.
8 onwards. The while impleading the same, the office shall take note that the respondent number 10 being the minor shall be represented by the respondent number 8 who is a father and a natural guardian. So
the application or extension for entry molar mail. application can number
After,
two.
after other application, after vacation.
Well, it can only
Your
extend. There
lordship
is-
has already admitted the appeal. So since it's at the time of admission, it was not brought to your lordship notice. That's why division made. Now he has to take steps before the learned single judge.
There is a well, extension after till vacation, well, 1 week after vacation, well, kindly extended. Well, there was
What is the interim order?
interim order injunction.
His suit, blood, that was stayed, blood, after the order of remand.
His suit is stayed.
Because
No,
blood,
no.
the order of remand is there. That's why your lordship has.
Further proceeding
Yes,
is
further.
Nothing is going. The court
Yes,
is
sir,
also
that's-
going to be closed. Go before. Yes, for the next.
It's my time for the appellant.
What is the defect, sir?
Yes, my lord.
There is a defect. What is the defect? Sir, out of time. Section 5 filed?
My.
You have filed?
Yes, my lord.
Which
There are
number?
two defects. One is for
Can do.
delay.
Service. There is no direction for service. Will not accept.
That's it.
Got it.
One is 51 days or 50 days.
Whatever, sir. Other side has a right to be heard.
Yes, my lord.
This cannot. You of your own cannot send it unless the court directs. The court may not direct the service dismiss. Then
Yes, my lord.
no service.
What's it only
1 week after vacation. Service 1 week after vacation. Call the next.
In this matter, Mr. Shushanjit Bonik is appearing for the appellant lordship because of his health issues.
Not this week.
Yes, lordship.
Next.
My lord's permission. 8990. My lord, 8990, my lord. We have already filed section 5.
My lord, 7 January, my lordship and my lord
My lord.
Justice Samanth.
My lord, several time matters
My
are
lord,
by
my lord, my humble submission is the
Please
my
see the
lord.
last order, my lord.
My lord, my humble submission is this, my lord. Mr. Amjad Ali, my lord, she is ill. That
She is ill.
he is ill. He is ill. Sorry. I may be speaking. He is ill. My lord, it may be fixed after vacation, my lord.
No difficulty. After vacation.
My lord, kindly see the last order, my lord. I have not received the section 5 application.
Yes, sir. Yes. Which,
Earlier occasion of the directed.
You give a copy. Here we now give a copy.
Yes.
Take it. Next. Whose order, sir?
Lordship and Honorable Justice Samantha Lordship.
Where is the other side? Mr.
Pankaj and
Pankaj Haldar, Vidish Ghosh, Tapus Manna, Kamarjit, Bilal, or Belal, I do not know. All them. Yes. Next.
So Passover Lordship.
Passover?
No, Lordship. If I not Lordship.
After vacation?
Lordship.
Yes, not this week.
Quantum is another 95.
Next.
93, I am for petitioner, my lord.
First time or second time?
The second time, we will be service.
Until and unless review application is hard, how contempt will be?
That is what is not there. Anyhow, not this week.
Not this.
Yes, next.
293.
It's 95 Lordship.
Did not respond. What can I do?
Sorry, 95.
294 years.
Sorry, my lord. My lord, I am for the petitioner, my lord.
So what you are standing in the respondent side?
Sorry, my lord.
My lord, Learned Counsel, Mr. Nilanjan Bhattacharya appearing for
Well,
Union of
last time
India, my
also,
lord.
my lord, they took.
Learned Counsel, Mr. Nilanjan Bhattacharya appearing for the Union of India, my lord.
My lord, it is your lordship's order, my lord. Your lordship has passed the order sitting with my lord Justice Samantu.
What do you want?
My lord, a spot accommodation, my lord. My lord,
Well, last.
my lord, as per the convenience of your lordships, my lord.
2 minutes.
My lord,
That is what he means short.
pardon, my lord, but my lord, he could not appear because he went to a doctor consultation with his son, my lord.
Not this week. Personal ground.
Grateful, my lord.
$295. Only for 2. 295. Somebody appears. Yes, sir.
96 my lord, I am for
96 295 is coming. You are appearing in 295.
95 a review application, Lordship.
Oh yes. So not this week.
Lordship.
96 I am for petition.
What is this? Whose order?
My lord and Justice Samantu, my lord.
So our orders are always flouted. Not not complied.
Yes, my lord.
Yes.
But they have, as per direction, they have used immediate, my lord.
So who are appearing for the
Only
LS contemners?
my lord. Nirmal Raj and Amitabh Chaudhary. My lord, Nirmal Raj and Amitabh Chaudhary. And I have also, they have used a affidavit, my lord.
Yes.
Amitabh Chaudhary, my lord, and Nirmal Raj.
Okay. After all, it's a contempt because they have to be sent behind the bar.
No, my lord. But they have used to affidavit, I am submitting a reply, my lord.
But affidavit, opposition is not with us.
Yes, my lord.
That will be a difficult situation to keep.
No, I am not.
They're just making it not this week. Anyhow, last working day.
Then after 35, my lord.
Immediately.
Yes.
We'll change it for you.
Get to, my lord.
My lord, I appear in copy of the mother petition, my lord. So I have to stop keep the this point.
Yes.
So first time, I need to respond to this. And we have filed an application for recording prior to the filing of the extensions. Extension of time, Miller. And Miller, the extension of time is
for recalling.
An extension. I have filed an application for extension of time.
Where is that application?
My lord, this application came up before your lordship. Before that, it was taken up by the Honorable Division Bench, Presided by Talukdar. Justice Talukdar, my lord, with the other Honorable Judge, my lord, they were of their lordships were of the opinion, my lord, this should be taken up by your lordships. Ultimately, my lord, going through the tenor of the order, it was the perception of this Honorable Division Bench that this should be taken up by the regular bench, taking up the group 2 matters. My lord, if I succeed in the extension of time, my lord, the contempt will not arise.
Obviously.
So that is why on the last occasion,
my lord, principal of
that application.
That application, application
Is appearing before the list.
My lord, no, since your lordships were pleased to release the application from your lordship's list, my application for extension of time, so it is required to be, my lord, placed before your lordship.
What?
On the last occasion, that application, before that.
No, this is not a regular bench.
Not regular bench, but unless my application is hard, and my lord, if I succeed.
Oh, I am asking what is the fate of your application now? What is where? It is there in the dump yard or it is there in the list? I just wanted to know that.
In the department. Last appeared before this court.
So my first notion is correct. Just let him go.
No.
My lord, my lord, principal of a college, my lord, remaining the suspense 5 years.
Yeah.
5 years. Sorry,
Yes.
5 years. My lord, this is my lord, kindly my lord, turn my lord, page 30, my lord. Page 30, my lord, we therefore modify the impugned order. First, my lord, order, my lord, mandatory. My lord, this modify. Kindly, my lord. The impugned order to extend the inquiry officer shall complete the proceeding within 31st January 2022. The time limit indicated herein above the peremptory and mandatory. And my lord, kindly, my lord, thereafter, my lord.
You have not completed it.
Milord, kindly she is the inquiry officer, Milord. Milord, what happened? Kindly seize. Kindly, what is there in the
Instructions? They made an application before me.
Who?
Honorable client, saying that you stay your hands in the matter because we have already moved the High Court in contempt. We'll bring that on record.
Then file your opposition.
Yes, within 3 weeks from the date of from the
File your opposition. 2 weeks after the reopening, reply 1 week thereafter. The application, and in the meantime, you take steps if you cannot get it extended.
kindly, Milord, let it be heard together.
No.
Otherwise, Milord, because it was your lordship.
No.
Then permit me to file a review application of your lordship's order for extension.
That is a different thing. That is a different one.
Your lordship's order, I secured, I said, Milord, there was a sufficient reason that not to comply. Why I could not comply?
No, after the inquiry officer has said, anyhow, you come after 3
Yes.
My lord, before your lordship's last, my lord, may I again, my lord,
এতে চলে যাও না, ওই মেডিকেল মেডিকেল।
কারোর একটা নাম্বার দিয়ে দিন ভাই। ঠিক আছে ও একটা ফাইল করবে আচ্ছা আপনি যাবেন বেরিয়েছে মাঝখানে কালারটা চেঞ্জ হয়ে গেছে এটা একটা ছবি হ্যাঁ কালকে একটা তুই আইটেম ছিল কালকে এক তুই আইটেম কালকে এক তুই আইটেম কালকে বলতে
না আমার হোয়াটসঅ্যাপে আছে ও ফর কারেকশন যেটা ছিল
হ্যাঁ হ্যাঁ ফর কারেকশন
না আমাদের আরেকটা I was already informed my client that I've already appeared on behalf of the appellant. So I have informed and taken steps for arranging engaging some other advocate in this matter.
What to do now? He's pressing hard every time that.
That I have informed, my lord.
What to do now?
My lord,
They have to engage.
yes.
What to do? Tell us.
My lord, your lordship directed me to serve notice, my lord. The notice is served because, my lord,
Yes,
He
but,
was,
my
he
lord,
was contacted.
yes,
It's not that the other side did not know.
no, yes, that's,
No.
What is an urgency that it
my
cannot
lord,
wait?
my lord, the execution is fixed in January, my lord, first week
When?
of January.
So
First
we
week.
can fix this matter on second. We can take up this matter on second.
Well,
We are also closed for the Christmas vacation, so they will be reopening on second. So we can fix it on second.
Then, my lord,
Yes,
it is
fix it on second, this matter. In the meantime, let them
Yes,
take
yes.
steps to.
I've already informed. I'll later hand out all the documents which they have.
I'm getting.
And item number 21, my lord, there is order 41. After vacation, my lord, there's some defects are there. The police have already issued.
What can be done? So defects have to be removed.
Yes, so but only the trial photocopy of the trial court degree is with me, not the certificate, because it was filed with the court below. Other defects can be removed here. All the documents I have.
Where is the certified copy? Why you do not file it?
The trial court is with me, my lord.
Simple application before the appellate court to return the certified copy. It is done in no seconds. If you do not do it, then what can be done?
The certificate copy of the judgment is with me, my lord. The degree. The photocopy of the degree is there. But
let us see.
Lordship, I am on behalf of the appellant, Lordship. Lordship, in this instant matter, with your Lordship's permission, I want to inform you that, Lordship, one caveat has been lodged by the respondent, Lordship. And just a few minutes ago, I came to know from the conducting advocate who generally appears in the learned court below related to this matter, one caveat has been lodged by the respondent, Lordship. So, Lordship, in that event, subject to Lordship's concern, service is highly required.
Second appeal. The respondent have no right of audience unless the appeal is admitted.
Lordship.
So if we admit the appeal, then we will definitely see whether the applications can be disposed of or not.
Lordship.
We'll have to first cross the hurdle of admission.
Admission, Lordship.
So argue on the involvement of substantial question of law. What is the substantial question of law involved in the instant case?
Lordship. Lordship, in a nutshell, Lordship, in a nutshell, the crux of this instant matter is that the plaintiff, that means the respondent, filed one title suit against the appellant. Appellant was the defendant in the suit code. The decree was passed in favor of the defendant. That means suit was dismissed.
First thing is, what is the suit for?
Suit for, Lordship, eviction.
Eviction of
the defendant.
Eviction of a tenant, eviction of a
Unauthorized trespasser. Trespasser.
Say that it's a recovery of possession against the trespasser.
Trespasser.
Now, then the trial court decreed the suit or dismissed.
Dismissed. Dismissed. Then, Lordship.
What ground it dismissed?
Lordship. Because plaintiff respondent claimed that I am trespasser. I am trespasser. Why I am trespasser? Because I purchased the property from a person who is a trespasser. So I do not have any right. But, Lordship, but the learned code below, that means the suit code, learned suit code, observed that any trespasser cannot declare another person as a trespasser. That means any trespasser cannot be evicted by another trespasser. Because if I am a trespasser, then the plaintiff respondent is also a trespasser. For example, Lordship, Mr. X is a respondent, that is my client. Mr. X purchased a property from Mr. Y. Now the plaintiff says that Mr. X doesn't have any right because Mr. Y is a trespasser. On the other hand, the plaintiff also purchased the land from Mr. Y. So if I am a trespasser, then the defendant is also a trespasser. So a trespasser cannot be evicted by another trespasser.
Correct proposition of law.
Lordship, by this second appeal, I am learning, Lordship. And for the purpose of enhancement of my knowledge, I am moving this matter before your Lordship. So it is an opportunity for me to learn.
Possession is a 9th principle of title.
Lordship.
You are aware?
Lordship.
A person having a possessory right, irrespective of any valid title in support of it, if he parted with the possession to somebody else, can he not recover that possession which he had in the property?
Lordship.
Whether the title has to be gone into, that possessory right title that is there. When you say X and Y, now I am giving you a more elaborative example. I am in possession of a property, may not be backed by any title, but I'm enjoying an exclusive.
I'm enjoying, Lordship.
I inducted you that you are the tenant. I am inducting.
Lordship.
I gave you a possession, physical possession. Possession is given by me.
Lordship.
On the strength of this possession, you have come into the property.
Lordship.
Now I filed a suit for your eviction. Do I have to say that I have got a valid title? No, because the possession is the important factor from whom you got possession.
Lordship.
So if you got possession from me, then I have a right to take back the possession from you.
Lordship.
So that relationship of landlord and tenant remained, because if you definition of a landlord does not talk about any title to the property. It says entitled to receive rent. What is the meaning of the word entitled to receive rent? That is, when I part you a possession, then I am entitled to receive it. That is why the possessory right is also recognized in the law. So far as vis-a-vis one trespasser with another trespasser is concerned. But no, you cannot be regarded as a trespasser vis-a-vis me. You may be regarded as a trespasser vis-a-vis my brother. He has a better title than me. So he can claim and say that both of us had no title. And he can claim possession on a better title. So this is how that can be done. I do not know how the trial court has said that one trespasser cannot evict another trespasser. From where he got this concept?
Lordship, in that event, Lordship, the family tree. Lordship, the family tree, because we are not a tenant or landlord. Family tree. Family tree is highly required. If Lordship, I will be given a chance to place before your Lordship the family tree, which family tree has been drawn by the learned suit court and as well as the first appellate court.
Different issue. That's a very broad principles when you said one trespasser cannot evict another. For that reason, I gave you another example that this may be a case where these principles will not apply. Now the question here is that family tree means everybody is tracing title from a common ancestors.
Common ancestors.
Now one has to understand that whether you have a better title or he has a better title. And if he says that he has a better title, he can definitely sue you.
Yes.
If you have no title.
Yes.
Then one has to understand that how he claims a better title.
Lordship, regarding this part,
plaintiff must have said that how he traced his title.
Lordship.
What he says.
Lordship, he says.
I have not opened my brief as yet. I am just simply relying on you when you said that you was the first time you wanted to come.
Lordship. Lordship,
Here is the fact.
originally the property belongs to Vidyadhar Mardullal.
Vidyadhar.
Vidyadhar.
My first name, Vidyadhar.
After that, Lordship, the property comes to the head of Tejendra
How?
by inheritance.
So Trizendom must be the son or what?
Tejendra is the grandson of Vidyadhar.
Then how directly the matter, the property comes to him? Trizendom's father was dead at that time.
Lordship.
Was he dead?
Lordship.
His predeceased son.
Predeceased son.
And he is the only grandson.
No, Lordship, now I'm coming. Actually, why I am saying why I am jumping directly Tejendra, because the share of the Tejendra was focused. If I am I want to segregate, then the Vidyadhar, then Shivnarayan and Kriparam. Shivnarayan and Kriparam, they are the sons of Vidyadhar.
So the Vidyadhar has two sons.
Two sons.
Correct.
Kriparam has three sons.
Three sons.
Ram Narayan, Ananda Narayan, and Ganga Narayan.
Three.
After that, Lordship, Ananda Narayan.
And Siu,
Lordship.
the another son, Kriparam, one branch. Another branch
Kriparam although has three sons, and Shiv Narayan had two sons. After that, Lordship, the son of Ananda Narayan is Nilkamal.
Ananda Narayan is the son of Kriparam.
Ananda Narayan is the son of Kriparam.
So Kriparam has three sons.
Three sons.
So one of the son is Ananda.
Ananda Narayan.
Ananda, yes, then?
Ananda Narayan. And Nilkamal is the son of Ananda Narayan.
Correct. So Ananda Narayan has only one son.
Only one son.
Nilkamal.
Nilkamal.
Correct.
After that, Lordship, Poshupati, Prajapati, Ganapati, Dibapati, Shochin, Sharat, Tejendra. They all are sons of Nilkamal.
So Nilkamal has five sons.
Five sons.
5 or 6?
1, 2, 3, 4, 5, 6. 7 sons. 7 sons.
So
now, Lordship, I am giving the proper focus on Tejendra, on the part of the Tejendra. Because from
one of the son of Nilkamal.
One of the son of Nilkamal.
Then
Lordship, according to the information taken from the LRO department, Tejendra was an owner of the suit property.
How can he? He has another 6 brothers.
Another 6 brothers.
They were all 7 brothers. So he has another 6 brothers. If Nilkamal died intestate, then his estate will devolve upon all the 7 sons equally. How Tejendra got the entire property?
Because the entire property was greater than the schedule mentioned property. Actually, the scheduled property was in the part of the Tejendra.
How?
By strength of the partition.
Say that you have missed that.
By strength of the partition.
All these 7 brothers, is it correct? All the 7 brothers have amicably partitioned their share.
Lordship.
Partition deed was executed.
Partition deed executed.
Come ready. On facts, you should be very, very ready.
Lordship.
Not that easy. And plaintiffs are tracing title from Sioux. Plaintiffs are tracing title from where?
Plaintiffs are tracing title from Tejendra. From Tejendra.
And you are a defendant.
I was a defendant in the suit court.
You are still a defendant in a suit court.
Lordship.
You are a defendant.
Lordship.
So you trace your title from whom?
From Tejendra, Lordship.
How? How?
Because Lordship, Tejendra.
Because the plaintiff is also claiming through Tejendra, you are also claiming
through Tejendra.
On what basis the plaintiff is claiming? On what basis you are claiming? Sale deed was executed by Tejendra?
Not by the Tejendra. Sale deed was executed by Ajit Omiyo, and Omolendu, all are sons of Tejendra.
Correct. So Tejendra also during his lifetime did not.
No.
So he had 3 sons.
He had 4 sons.
4 sons.
4 sons.
Okay. Then 3 sons or all the 4 sons sold the property to plaintiff.
In favor of the Vishwanath. In favor of the Vishwanath. Vishwanath, that means the defendant. Vishwanath, that means defendant.
So all these 4 sons of Tejendra sold it to Vishwanath, means your client.
Lordship.
Defendant.
Lordship.
Correct?
Mhm.
How plaintiff traced title? He must have said that how he has acquired a title. How he says.
And Lordship, some part of the property was sold out in favor of the plaintiff also.
By these 3 sons of Tejendra.
Lordship.
3 sons.
Lordship.
No. These 3 sons have sold. Whose sale deed is earlier and whose sale deed is later?
The sale deed in favor of the plaintiff is the earlier.
And
But not the same property, Lordship.
so not on the same property. So these sons have demarcated the whole of the property into 2 parts. One part is sold to the plaintiff,
Lordship.
other part is sold to the defendant.
Defendant.
Is it your case?
Lordship.
No difficulty?
No, Lordship.
Okay. Now the plaintiff has said that in his part you have encroached. Has he said so?
No.
He has not said. Then
No.
why he asked for your eviction?
Because Lordship, the plaintiff is saying that I do not have any right, and that's why, Lordship, I am saying that one trespasser cannot be evicted by.
How can one trespasser? Tejendra's son were in their lineage, they had a title. How can one trespasser will? How the concept of trespasser comes?
Because Lordship,
It's a claim of rival title. It's a claim of rival title. Now, once you say that this larger property which was there in the hands of Tejendra went to the 3 sons, they 3 sons have amicably demarcated half portion or whatever the rear portion or a front portion, whatever. A portion thereof is sold to plaintiff, a portion thereof is sold to defendant. It is not the same which is sold to them. There must be a demarcation in the sale deed.
Which was exhibited in the suit court.
Sale deed must have the boundaries.
Lordship.
If there is a boundary then one has to understand which portion and then tally with the boundaries of the plane. Prepare yourself.
Lordship, after vacation, I will place it.
Come.
I will place it before your Lordship.
Yes. Read that. Second appeal is not that easy task.
Lordship.
It's the most complicated job of a lawyer in a second appeal.
Lordship.
Most complicated.
Lordship.
You should marshal the fact. Law you will learn by passage of time.
Lordship.
But facts, every junior member must marshal it.
Because fact cannot be twisted. Law point may be twisted, but fact
No,
cannot
it
be
can
twisted.
be twisted. No difficulty. It can also be twisted. There is no difficulty. But one must know the fact because it
Lordship,
is
kindly
all
give a date, Lordship, in that even after vacation.
vacation. Come. 2nd
January, Lordship.
Yes, come. But come ready with preparation. Note how one trace title, how you can do it.
Lordship. Deeply obvious. 2nd January.
Yes.
My lord, 103. My lord, 103. Mr. Prosenjit Devnath is appearing in this matter on behalf of the appellant. I am praying for not this week. Grateful, my lord.
For the 110.
Yeah. Argue. Second appeal.
Yes, ma'am.
1916, 1918, 2016, 17 appeal.
200. My lord, this suit was filed or
First, tell
declaration.
me you are defendant or a
Defendant number one.
This is 6 में ये तो 2001 के 22 बरस के बाद एडिशन के बाद उस समय देखिए इसका बच्चा Section 5 allowed?
Yes, my lord.
Parties are still alive.
My lord.
Still alive. Are they still fighting?
My lord, in the section of application, do I file?
No. Are they still fighting?
Yes, my lord.
Fighting. Okay. This is too much. Yes, what is this?
My lord, this is suit for.
You are a tenant?
No, my lord. The case is that we purchased, but there are 7 co-sharers admitted.
What is a suit for?
Suit for declaration and permanent injunction.
What declaration of title or deed to be void? What?
My lord, the declaration of their title.
Title.
And
So what the trial court did?
trial court, my lord, decreed the suit in 2 grounds. One is adverse position.
Adverse position allowed.
Adverse position as well as the deed. Both. They claim by the deed that they are in position, and court also held that he also advised the position. Malad, the case is Malad, the 7 co-sharers.
You are a defendant number 1 in the declaration of title and permission.
Lordship, you kindly come to Malad, the
Yes, and the first appellate court dismissed it. First appellate court dismissed the appeal.
Before that, Malad, the suit was also dismissed, also allowed.
Suit was decreed, appeal dismissed.
Yes,
yes. What is the substantial question of law?
Question of law is that they filed the plaint. There they have stated that there is admittedly 7 co-owner.
Yes. 1
co-owner by amicable agreement got this plot according to the plaint. Now, my lord, from the deed, their deed itself, they say that there is amicable settlement in writing. Only one person from vendor, as a vendor, only one brother, he sold the entire 7 share. 7 share, but that is the one plot, 29 decimals of land. But
he sold the entire 16 annas share.
Yes. And
pure contention.
Yeah, this is their claim. And
they say they by amicable arrangement, this property has been allotted to me. I have become an absolute owner. Now he sold it.
Sold.
Then
we also purchased remaining 6 owners sold us. Okay. 1 person is given them. Remaining 6 persons sold by
to you.
Yes.
Now the question is amicable partition.
Amicable partition.
Yeah.
Now there is no documents was produced. No evidence of that persons, those who sold this property, were adduced, were taken, were evidence was not.
Why they are required to be?
No, nothing of that was given. If we have taken our exception that
Yes.
we have taken our exception that there is no partition, no evidence, nothing of the sort, and our deed also said that we never parted position with anybody. We purchased and we also recorded our name.
Yes.
Their name was not recorded in the LR record of right. Our name was recorded.
Yes.
Then they filed the suit that I forcibly evict them. Now, court below, while the decide the suit, they did not find that any person, any person that is the main, the witness should be the defendant number 3, whose pro forma dependent, who sold this property. He was never deposed before this court. And my lord, the lordship can see the court giving onus to us. Why we did not examine, but how we can? We are the defendant. We are under the plaintiff. Defendant, plaintiff should
Did you produce your deeds before
deed,
the
yes, we have did produce our deed and also our record of rights. Record of, not only that, if a person, we have said, he definitely can sold this property, but 1/7 share always with him. Definitely, the one son, admittedly one son sold this property, and even they, in their evidence I can show, my lord, they did not, they said they are not, they have got no knowledge about the other question. But in the plain, they say
purchaser who has purchased from the vendor who claims that I am a 60.
Yes, but they said
then
in the
how can you
evidence
say that there are other co-sharers. They
no,
are
no,
not supposed to say.
they do not. In the plain, they have said. In the evidence also, they said.
Nothing. Just give us 1 minute. What you were doing for so long? From 2001, you did not attempt to get.
The file could not be traced out. Several times I mentioned we could not trace out the file.
Why it could not be traced out?
I don't know, my lord. I tried my level best, but I could not. Otherwise, this should not be waiting for so long.
Yes. The appeal shall be heard on the following substantial question. First, whether both the courts below were justified in decreeing the suit, holding that the plaintiff respondent have perfected the title by adverse possession without returning any finding as to the as as to when the plaintiff has
claimed hostile, uninterrupted title by way of adverse possession. Next, 2. Whether both the courts below were justified. Now, in arriving at the conclusion that the plaintiff respondent has right, title, and interest in respect of the suit property, when admittedly one of the son of the original owner executed the sale deed claiming an amicable partition, whereas the others also executed a deed claiming an undivided right, title, and interest in respect thereof, thereby impliedly denying the story of an amicable partition. Lower court record, is it alive? Lower court record is alive, destroyed. Must have been destroyed by this time. 22 years you were waiting, sleeping in a slumber. A lower court record, special messenger 1 week after the reopening, requisites for effecting service 1 week after the reopening, paper book 6 weeks from date. File it. Appeal of which year?
2016. And I had brought the genealogical table of the. It was a hard last week.
We forgot everything. What is the fact? Why we wanted a genealogical table?
Plaintiff is the defendant in the suit. Judgment against affirmation, my lord.
Suit for
declaration and injunction.
Declaration of what?
Title.
Title. Yes. What is this?
This is the genealogical table, my lord.
Yes.
Suit property. I have given the short note of the cases.
So the suit property originally belonged to Kabir Singh.
Kabir Singh and Imajuddin.
And Imajuddin.
Imajuddin.
Both jointly. Then Kabir died with Sovan Ali, Kharshed Ali, and Akidennesa.
Akidennesa, wife.
That is a wife.
Wife.
And
Imajuddin died isuless.
And several daughters. 1, 2, 3, 4,
5 daughters.
5 daughters.
Yes.
And this Imazuddin left
isuless.
What do you say? Sisters?
Left isuless.
His
sisters and one wife. 3 sisters and 1 wife.
This Kabir was alive?
No, died.
Prior to
death of Imajuddin. Both are dead now.
No, I know. Prior to Imajuddin or after Imajuddin?
Before the death of Imajuddin.
Before. Yes, then?
Then, my lord, Sovan Ali is the son of the Kabir Sheikh.
Who is the plaintiff?
Plaintiff is the defendant number 1. Sovan Ali is the defendant number 3.
Here?
Defendant number 1 only challenge there.
No, who is he? Anybody from this?
No. Only defendant number 3 and defendant number 1.
Defendant number 3 sold to defendant number 1.
No, defendant number sold one Mimasa, defendant number 12.
Who?
By oral Heba.
Thereafter, defendant number, profound defendant number 12 transferred the property, the plaintiff.
Who is the defendant number 12?
Defendant number Mima Sat.
I do not get the name here.
The son of the Soman Ali. Defendant number 1 and Mima Sat is the son of the Soman Ali.
The defendant number 1 and
defendant number 12. Both are sons of Soman Ali.
Sovan Ali.
Yes.
So Sovan Ali, they claim through Sovan Ali.
Yes.
They sold it to
Soman Ali gifted property his son
by oral heba
by oral heba
to his 2 sons.
One son.
Defendant number 1?
No,
or
12. Only 12.
Only 12.
12 transfer the property by way of sale to the plaintiffs.
Okay.
The defendant number 1 purchased the suit property from Sakidan Nesa. There is a record of right in the name of Sakidan, wife of the Imajuddin.
Oh, Sakidan.
Yes.
Sakidan. Then?
12 decimal of land recorded in the name of Sakidan and 78 decimal of land was recorded in the name of the Sovan. The Sakidan claiming to the record of rights.
What happened to Khurshid?
Khurshid, no, there is no
trace. Okay.
And one compromise decree, one suit was filed by the profound defendant number 12, Mima Sat. And in the compromise, in the said suit, one compromise decree was passed. But the appellant was the made party in that suit. Before filing the WS, without signing the solenama, the decree has been passed without signing the in solenama by the defendant number, by this appellant. And in the judgment, only that document that already a compromise decree has been passed in favor of the Mimasat. Mimasat sold the property to the plaintiff. Therefore, the defendant have no right, title, interest to the property to interfere with the plaintiff property. This is the case.
You were a party in the compromise decree.
Yes.
And
In
the suit has been dismissed on the ground of compromise decree.
Yes. Suit has been decreed. I am the defendant in the suit.
Okay. So you were a party in the
compromise. Yes.
So, and the plaintiff was not a party to the compromise.
No.
Now, can you justify your stand? Tell us. Can you justify your stand?
I am the purchase the property from Sakidan Nesa. I have a title. I have a title deed. So without.
But the court has said that the compromise decree is not binding.
Compromise decree is binding.
On the plaintiff?
Yes.
Oh, he was not a signatory.
No.
Then?
My client is not a signatory also. He may, although he is made party.
Who was not a signatory in the compromise petition?
My client.
Your client was not a signatory.
Yes.
Plaintiff was a signatory.
No.
Plaintiff's vendor was a signatory.
Yes.
Now I got it. Why you say no? I got it. You will say no. Your vendor was a party to the signatory.
No.
Your vendor was not a party.
He was not made a party also. My vendor has not been made a party in that suit, compromise suit.
I do not know. Let us see what can be done. After vacation, we have a special bench at 3. After vacation.
Before your lordship rises, my lord, item number 20. Item number 21. If your lordship kindly takes item number 21, if your lordship kindly takes up tomorrow. There is a police help already been issued for delivery of position. Police help already been issued for delivery of position. There's some defects we are trying to cure the defect. That's why we only yesterday could not.
We are simply a recipient.
Our submission, my lord, we have completed and we have given it the fresh copy.
Pursuant to my lord directions, Ropa 1981, 1998, 2009, 2019, and staff pattern and control of
This
expenditure.
is what is most needed. We did not want the only submission is only for checking purpose, nothing more than that.
My lord directed that from the state side.
So this was Mr. Bhattacharya. So
No, we
so
accept
this is the only small correction.
only very small correction.
Sufficient submission has been recorded, my lord. We have checked it up, and Mr. Chaturvedi also, my lord, said it is correct. Now, 3 additional points. Your lordship, other they pointed out to give the 3 additional points. One is, my lord, regarding overriding effect. And I have found one judgment. It has been held, but of course, my lord, by a single bench, that it does not have any overriding effect since already the accrued right is there. I have annexed this judgment. The second point is staff pattern. One judgment, my lord, clarified the issue. It is violative of Article 14. That judgment also I have annexed. Third point is, my lord, whether circular is whether governor assent 593 circular. My lord, I have got one RTI reply of the government authority itself. They said it has not been, my lord, public officially, my lord, gazetted in the website, official gazette of the government. So I believe this is merely an executive circular. This is a government document is there. And I have paginated this. Justice Banerjee's judgment is there, quoted that portion, paragraph 11 to 12. And I have made this point.
Yes. Yes.
Three judgments, my lord, and that the official documents.
No, show us which portion of three judgments.
Yes, my lord.
What additional thing you have given, please show us, otherwise we'll not.
My lord, okay, first judgment is, my lord, page 9, internal page 9. 3 copies I have given. Paragraph 10, 11 of that judgment, it has been indicated. Paragraph 9, 10, 11 at page 10, my lord, kindly sees. Internal page 10. My lord Justice Banerjee, in a case of Tilochon Jana, it has
Yes,
been.
that we have considered.
Yes.
That we have considered.
And second judgment is, my lord, page 13. Of course, it is not a single bench, but paragraph 20.
Tilochon Jana has been cited before us. So
Yes, yes. And then third point, my lord, that executive instruction point, it has not been officially gazetted. My lord, page 21. It is the RTI document of the government deputy assistant secretary. Page 21, kindly sees.
there is a judgment of Justice Division Bench presided by Justice Dipankar Datta.
Yes.
We are not. I could not. I read that judgment, but I'm not where this point was addressed.
Yes.
I'm trying to find out, but I could not.
Yes, that judgment is, if your lordship record, I have.
There's a judgment.
Mr. Jahan probably appeared.
Division bench judgment.
Division bench judgment.
That give the judgment to us.
Yes, indication is there.
So you have not included the judgment.
Since the document is there, if your lordship
Give the judgment to us.
says I can.
No, when will you give us?
By tomorrow then. I have that copy itself with my chamber. আচ্ছা একটা দেখিয়েছিল my lord considered in a division bench. And I have annexed one of the honorable division bench judgment by Justice Datta in Kakoli Chatterjee court settle most probably. But in my compilation it is there. All these points discussed there. It went to the Supreme Court, remanded back, review dismissed again, my lord. Supreme Court dealt with it. Again.
No remand.
The second time no remand. Admitted.
Yes.
Admitted in view in favor of the petitioner. Pay scale to be given. That is there. It is in my compilation. It is there.
This is you have given.
No.
No.
557.
What are the other What are the other notes that we have handed over? Yes.
557 appeal. Appeal. It is there.
Mr. Jana is agreeing. Yes, correct. Yes, please, no.
And Chaturvedi attorney.
No problem. No problem.
And Chaturvedi also admitted that it is correct. And the date of the Supreme Court, 24th. I have got that order copy itself. 24th of January.
Which day? 24th
24th January, it was fixed before the Honorable Supreme Court. I said second week, but specifically it's 24th. That order itself is there. Yes, it is recorded. So I shall give that second copy, third copy also. দেওয়া আছে compilation.
Yes.
Argument concluded and judgment reserved for that reason. It has been fixed for 8 weeks after. It is 24.
For judgment.
Your loss after delivery of the judgment, they will take the matter.
The matters will be adjourned by 8 weeks to await the judgment list of 24 judges.
হ্যাঁ হাইকোর্টের জাজমেন্ট রিজার্ভের জন্য
Yes, anyone else?
Yet full till. And so far as my lord Somoresh Dhara, I did not catch him.
You could not catch him.
This is the copy your lordship given me to.
But it's a Chaturvedi's thing. We have not had.
I have handed one.
Chaturvedi দাইনি দিয়েছে ধারাতে থাক
যা আছে তাই whatever there it is there. Yet full till.
Yes.
So, thank you.
Much of
One fact to be placed before us. After 1st April 2010, Right to Information, Right of Children Free Compulsory Education Act 2009 came into force. There is no provision for appointment of honors graduate or postgraduate. 1st April 2010, there is no provision for appointment of postgraduate teacher or honors teachers up to class 8.
Up to class? Okay, what is your answer to? Yes, all of you are asked to give the judgment of the division bench in Tarok Rai.
Tarak Nath Rai. We have relied on Tarak Nath Rai.
We have asked you, all of you, to address us on this. What is your answer to Justice Banerjee's observation that going by the staff pattern in the junior section, just a minute, that if the subject is same, you require one postgraduate or honors graduate teacher and two postgraduate. All three of them are teaching the same subject. Then why you should not be allowed?
Because there is no such provisions.
No. What would happen to what would happen to those candidates prior to 2009? We are deciding the issues prior to 2009. We are not deciding on the 2010.
After
So up to 2009, you can, what is your
after staff pattern does not permit it.
My lord, in the
Banerjee's judgment indicates that you have given the course earmarking for past graduate and the honor graduate or a postgraduate.
Yes.
But they were all imparting the same class students. Same. So they are discharging the same functions. You say that from 2009, after this certain departure has come where the honors or postgraduates are not permitted to hold the class below 8, class 8. Now
Right,
it is given after class 8. This is what he said.
Okay.
So reaction is prior to 2009, if this is a correct state of affair that you impart, then
First November 1997 cut-off date. Just 1st November 97 is the cut-off date when School Service Commission Act 1997 came into force. On that date, if somebody is recommended for
Mr. Mukherjee, you are not understanding our query. Both the judgments are after 1997 Act. Admit?
Yes.
Let us admit on facts.
Yes.
It is also admitted that so far as the staff pattern is concerned, for the junior school,
high school,
then
arts and
whatever
school.
is there, even for the junior section in the staff pattern, you include one honors graduate, two. See the judgment in the
No.
Page 21 of the
Annex the staff pattern also from
No,
1974.
answer by Honorable Justice Banerjee.
both of you
Yes,
speak
it is
together.
there.
Judge को बोलते देना क्या?
Page 21.
Please allow us to speak. So Justice Banerjee said that the staff pattern, he has quoted the staff pattern in that particular judgment. This is the staff pattern which you have given in your affidavits, which shows that for the junior section, there is one honors graduate, two postgraduate. So 1 to 4. So 1 to 4, these all the three teachers are teaching the same subject. But the same subject. But so far as the higher scale of pay is concerned, if these two postgraduate students, they become honors graduate, if maybe they are teaching in the junior section, they were not given the higher scale of pay. So the rationality is this: if all of them, all three of them are taking the same classes, same teaching subjects, then why this staff pattern would be a factor in denying them the higher scale of pay? This was the question.
Nobody has challenged the staff pattern.
That is why, my lord, that is why kindly come to page 21. Subsequently, my lord Justice Banerjee, taking consideration also Tarok.
You are not saying it. No, Justice Banerjee's judgment does not speak about Tarok.
Subsequently, in a single bench, answered this.
Which one?
Page 21, kindly see.
Page 21
of fresh compilation of mine. That is why I am saying.
That is why I wanted single message judgment to clarify.
Clarify the position itself there.
That you have included here now.
That is why I am giving this. Answer page paragraph 21 dealing with the staff pattern of junior section.
The hearing concluded.
Not that parties are closed. The parties are silent.
Oh, the parties have filed their respective
additional
response. Additional response. And have made this and have also made submissions on the clarification sought by the bench. That is going to be reserved for judgment.
On the one line, the notification, you'll also ask for that. File before.
The compilation is submitted by the state, which is kept on record.
Yes.